Welcome to the Responsible Negotiation Podcast, produced by the DC Mediation and Dispute Resolution Institute. I am your host, Francis Ojok. Here at the Institute, we prevent, manage, resolve, and transform conflict into an opportunity for positive change using mediation and other appropriate dispute resolution mechanisms. Visit our website to learn more or contact us at info@dcmediationinstitute.com and let us know how we can work with you or collaborate with you. Without further ado, let's get to the show. Today, with great honor, I am delighted to welcome our esteemed speaker, Mr. Fola Alade, who will present on mediation, the future of dispute resolution. Fola is a notary public and an accredited attorney mediator based in Lagos. He is the founder and principal partner at Fortefa Partners Legal Practice, a bespoke mediation firm in Nigeria. He is a fellow of the World Mediation Organization, a mediator of the Global Mediation Panel at the Office of the Ombudsman for United Nations Fund. So, aside, without wasting time, allow me to invite Fola to take the center stage and lead us through this engaging exploration of mediation, the future of dispute resolution. Fola, the platform is yours.
Thank you so much, Francis, for the introduction. Good morning, good afternoon, good evening from wherever you're tuning in. So I'd like to welcome everyone to this topic on mediation, the future of dispute resolution. There's so much to unpack, but I'll try and see if I can at least set the ball rolling and see how far we can go within the next 45 minutes. So please, I don't take it for granted that we have people from all around the world listening to me. So if at any point in time I'm going too fast, kindly call my attention to it and I will slow down. So we're looking at the topic mediation, the future of dispute resolution. But before we get into the future of something, I think it's important to take a back step and look at where we're coming from, where we've gotten to, and where we intend to go into. Now, the first starting point really is the concept of conflict, because essentially what mediation is an amicable resolution of disputes with the help of a third party neutral. So the first starting point really is what I would like to call the etymology of conflict. And I'll be looking at it from 2 points of view. The first is that conflict is innate in us, innate to the effect that we were all born with conflict. And I'm sure at no point in time, save for those who actually went into boxing and wrestling, we all have had cause to have one misunderstanding in form of an argument, in form of an affray with someone. So that shows that to a large extent, we're all born with conflict. Now, apart from the fact that conflict is innate in us, conflict is as old as mankind. And if I have to go back in time from when the world was created and fast forward up until the evolution of industrial revolution, we can see that we've had elements of conflict with us. So many years ago, the mode of resolution of conflict had to do with fightings, conquering of territories, and all of that. But as human beings evolved, so did the mode of conflict revolution of resolving conflicts to also evolve. But I'm going to take it from the standpoint of the Industrial Revolution, when we'll be looking at the first, second, third, and fourth Industrial Revolution. And for those that are familiar with that, I'm talking about the introduction of coal, gas, and electricity. Now, while the world was going through innovation, something was also happening to conflict. Conflict was also evolving to the extent that it became a hydra-headed monster, to which for every time you try to cut off one head of the conflict, 3 or 4 more came about. Now, before we also look at dispute resolution via mediation, let's look at how so many, I'm careful not to say platform, but organizations have also come up with, as far as conflict is concerned. We've had the military coming up, we've had the police coming up, we've had so many institutions coming up, all with the hope of trying to prevent conflict. And conflict also started evolving. We started having criminal conflict, commercial conflict, so many types of conflicts to mention the list. And one thing you all need to understand about conflict, ladies and gentlemen, is that the concept of conflict is a multi-trillion-dollar industry. Because at some point or the other, so many organizations are coming up with trying to not only prevent conflict, but resolve conflict. Now, let's just bring it home to civil commercial. Now, for the longest of time, litigation has always been a way of having disputes resolved. But as conflict began to evolve, we've also had instances where some schools of thought have come up with the fact that rather than having conflict being resolved through litigation, let there be an alternative way of having disputes resolved. Hence the term alternative dispute resolution. Now, why it is important to put all of this in context is for the listeners to understand that mediation is a branch of ADR. ADR is a broad term that means alternative dispute resolution, which essentially refers to any means of settling disputes outside of the courtroom. So by this, we have litigation on one side, then we have an alternative to dispute resolution on the other side. So essentially, ADR really is an umbrella that encompasses quite a lot of things. We have mediation that we'll be going into. We have arbitration, which is very popular. We have negotiation. We have conciliation. We have collaborative law. So all of this fall within the broad spectrum of ADR. Now, to put the concept of ADR into proper perspective, dear listeners, ADR can be likened to a toolbox. And this is one of the things I always try to explain whenever I have an opportunity to train. The whole idea behind ADR is to pick from a tool, to the effect that if you pick up a spanner to try to unscrew something and the spanner does not work, you pick up the screwdriver, you pick up the plier. But what we're trying to say in the concept of ADR is that you adopt what is called more or less the NMA approach, to the effect that you try negotiation. If negotiation fails, you look at mediation. If mediation fails, then you can then look at arbitration, more like having a trajectory to having disputes resolved. So hence the reason why I try to liken ADR to a toolbox. Now, let us now get into the topic of today, which really is mediation. What is mediation? Mediation essentially is an opportunity to resolve disputes without having to resort to formalities. Francis, if at any point in time you lose me, kindly let me know. Thank you. So, or mediation can also be said to be a voluntary and private dispute resolution process in which a trained neutral helps the parties to reach a negotiated settlement. So essentially what we're talking about is that once there is a dispute between two parties and they have resorted to having that dispute resolved amicably using a third party neutral, that is mediation. Now, today's lecture is really not to train people on how to become mediators, but just to open your eyes to the benefits of mediation. And I wouldn't say the future of mediation, because I dare say the future is actually now. So one of the reasons why I want to start off on this standpoint is that there is a mindset ascribed to mediation. And I'm careful not to want to call mediation a calling. But you see, once you get deep into the business and practice of mediation, you will find that where conflicts are concerned, where dispute is concerned, it is not just black and white. There's this gray line in between all of it. So there's a mindset ascribed to mediation. There's a mindset ascribed to an amicable way of having dispute resolved. There's a mindset ascribed to the fact that even though you know that there's a presumption that you feel you have a good case, you are willing to have an amicable resolution of the issues issues concerned. There's a mindset to the fact that it is always forward ever and not backward ever. There's a mindset to the fact that you don't see the arm of dispute resolution as a way of trying to punish the other party for whatever the other party you feel may have done. So that is why the mindset is really very, very important in the scheme of things. Now, before we also delve properly into the future of mediation, it's also very important to highlight some of the careers that are under mediation, because some people think that where mediation is concerned, the only career under mediation is being a mediator. But I dare say that a lot of us have barely scratched the surface of the opportunities that are in mediation. So that's why I'm going to look at the careers. Some of the careers in mediation, number one, is that you can be a mediator. And within the broad spectrum of being a mediator, you can actually decide to become an institutional mediator. By institutional mediator, what do I mean? You can belong to as many dispute resolution organizations as possible to assist to them in resolving disputes for a fee. Now, because of the universality of ADR, because of the universality of mediation, for as long as you are accredited with an organization, you can actually practice mediation anywhere around the world. So that I think it's also very, very important to state that. So you can actually, and that's as far as being an institutional mediator is concerned. You can also be a private mediator, and you can also be a mediation advocate. For the benefit of those who don't know who a mediation advocate is a lawyer that represents his client at mediation. Now, of course, we know that within this broad spectrum of ADR, the doors are open to lawyers and non-lawyers. So you can actually even represent your clients at mediation as a mediation advocate too. You can also decide to have an independent mediation practice. Like what I practice, I have a bespoke commercial practice in mediation, and the only thing we do is mediation. You can also be an expert mediator in a certain niche. Ladies and gentlemen, we're in the era of specialization. The days of master of all and jack of all is giving way to people now specializing in different areas. So if you are inclined to go down the area of construction law, you can go down construction law. If it is maritime law, you can actually do that. And you can also even have a career in training, facilitating, and consultancy. I felt it's only important I call your attention to that. And of course, as far as the broad spectrum of dispute resolution is concerned, there is practically no case mediation cannot come into play. You can use mediation for property disputes. You can use it for debt recovery. You can use it for construction disputes, medical negligence, accidents and torts, to mention a few. You can use it for contract enforcement. You can use it for small claim. So one thing I try to make people understand where mediation is concerned is that mediation is like a key. It's like a master key that can open almost any door as far as dispute resolution is concerned. Of course, some schools of thought will say that there are certain criminal areas that mediation may not be used, but that is one conversation for the sake of time I don't really want to get into right now. Now, we have spoken about the careers, we have looked at the etymology of mediation. But one question we should ask ourselves is this: why mediation? Why? What is the whole essence of mediation? The first starting point I'll be looking at really is a court system. Now, I'm careful not to use the word delay. I would rather use the word congestion. And why that is so is that now, because of the innovations coming up right now, artificial intelligence is now taking the world to a whole new level. So while we're having so many of these innovations coming up, conflict is also evolving. So we now have so many cases coming up. And one thing I must add before we go on, I know it's in the next 2 or 3 slides, is that mediation can be likened to the technology of dispute resolution. Now, what is the value proposition of mediation where dispute is concerned? Number one is speed. The second, when it comes to having disputes resolved within a specified period of time, mediation is always the preferred method of using. Number two is the possibility of restoring that business relationship. That is number two. Then number three again is the synergy or the connection mediation has with technology, to the effect that you can actually practice mediation from anywhere around the world for as long as you have an internet. So like I stated earlier on, the first one is the delay in the court system. You cannot with certainty say that you can have your dispute resolved within a particular period of time. But if all the parties are on ground and they are willing to settle, I dare say that you can actually have mediation resolved within 3 or 4 or even 5 hours. And of course, depending on the sensitivity of the dispute involved, one of the backbones of mediation is confidentiality. So if you decide to go through mediation, you are rest assured that whatever it is you say will be within the confines of the session, hence confidentiality, which happens to be one of the principal backbone of mediation. Another one that would also be looking at, like I mentioned earlier on, is speed. Now, why speed is important is that we're in a fast-paced world whereby at every point in time, people need to be able to project how long it's going to take for a dispute to be resolved. And that's one of the things about technology. You know, the way technology works, things are moving very, very fast. So where mediation is concerned, there's a speedy resolution of issues in contention. And of course, the evidence is quite simplified. And I'm sure the lawyers here can actually testify to it. Where litigation is concerned, you actually have the Evidence Act that you have to rely on. But where mediation is concerned, evidence is simplified. You don't have to have the whole primary, secondary evidence, certified true copies, and whatnot. For as long as you're able to show proof of certain things in existence, it will suffice in terms of evidence. Now, like I mentioned earlier on, the connection mediation and technology has is seamless. And ladies and gentlemen, ADR has evolved into ODR. So when we're talking about the future of mediation, like I mentioned earlier on, the future is already now. And one thing the COVID did was that COVID actually accelerated mediation. Now, the conversation right now is no longer even about online dispute resolution. So while ADR is evolving to ODR, and in some certain countries has evolved into ADR, the conversation, ladies and gentlemen, is the infusion of artificial intelligence into mediation. So that is the conversation that is going on right now. So if we are looking at what we have right now, the future of justice is ODR, and technology is fast shaping the dispute resolution ecosystem. I'm here in Lagos, Nigeria. We have some of you that are tuning in from all around the world. What technology is doing or has done is that it has turned the world into a global village. Hence the reason why we need to talk about online dispute resolution. Now, please bear in mind that while we have ADR as an umbrella of so many forms of dispute resolution, essentially what ODR is that it refers to the incorporation of the internet, website, and email, and every other form of information technology in the dispute resolution ecosystem. Now, it can also be said to be services which are offered entirely by electronic means without the need of the disputing parties to leave their house. Now, if you look at what the infusion of technology into what it is that we do, what does technology do? It makes life faster. It makes things easier. That is also what ODR is doing in the space of ADR. Now, if what we are having right now is a form of online practice, because I'm actually disseminating information using technology. Now, there are so many bespoke ODR operating platforms around the world. We have Modron, we have Quake. In the United States, we have so many, we have at least 55 of them operating. We have some bespoke online negotiation platforms. We have bespoke online arbitration platforms, and some of them too are also online mediation platforms. But interestingly enough, some of the regular platforms online video conferencing we use, like Google Meet, Teams, and Zoom that we're making use of right now, is also being used extensively for having disputes resolved. And one of the reasons why Zoom seems to be one of the preferred ways of preferred online dispute resolution is because of its global use. It has over 300 million daily users. The users do not need to create a specific account unlike other ODR platforms. It is easy to set up. The interface is easy to understand. It has an immersive host control, and you have the use of breakout rooms. You can also have it has file sharing options. So across the globe, the Zoom platform seems to be one of the preferred platforms being used.
Are you ready to become the change you want to see in your community or in your workplace? If so, check out our tailored workshops and mediation skills, training, and certification designed to equip you with the practical skills to become an effective conflict resolver and a certified mediation practitioner. Now, Let's get back to the show.
Now, a lot is being said about ODR, but ladies and gentlemen, artificial intelligence is coming into play. Artificial intelligence is a game changer. And when I'm having conversations with some of my colleagues around the world, and they are still talking about ADR, I look at them and I smile. And I tell them, now, you're talking about ADR. In some countries, they're talking about ODR. I'm sure by now you know what ODR is. And in some other countries, they're looking at the infusion of artificial intelligence into ODR. Now, there's almost like an AI marketplace. I saw a documentary on the infusion of artificial intelligence into mediation, wherein people could literally wear this virtual glass, wear this I don't know what it's called, like a virtual glass or something that can teleport parties to like a virtual room. Then you get into so from anywhere you are, you can actually, it's almost like a virtual mediation room where you are there with other parties to have disputes resolved. That is the conversation we're having right now. You know, we have the Chat GPT, we have Apple Siri. Now, what is even happening right now with some mediators is that what they do with some of the cases is that they give a brief summary and then ask Chat GPT to come up with likely questions they can ask. You know, so a lot is happening right now with the infusion of AI into mediation. So the question I always ask whenever conversations like this come up is that in all of this, where are you? In all of this, how well are you able to appreciate what is happening right now? Because the way mediation is moving now, ladies and gentlemen, when we started close to 10 years ago, it wasn't like that now. So a lot has been said about ODR, so that it's very, very important to look at some of the benefits of it, top of which is that it complements the dispute resolution. Now, one of the one reason why ADR seems to be preferred is because of the multiplicity of options at play, to the effect that you can try negotiation. If negotiation fails, you look at mediation. If mediation fails, you look at arbitration. Now, you can imagine a scenario whereby now dispute resolvers actually have the option of ADR, which is physical. They have the option of ODR. So there's really no excuse about not being available. So, you know, so ODR more or less complements ADR. It is also cost effective. Now, cost effectiveness in terms of parties not having to travel from one jurisdiction to another. Cost effectiveness in terms of time. You can quantify a lot of things, but can you quantify time? It's also very quick. There's also the geographical flexibility that I mentioned earlier on. And it's also adaptable for small and large claims alike. And one thing is also now, because of the improved level of security and safety features that have been introduced into it, you can be rest assured that whatever manner of having your dispute resolved is concerned, there is actually confidentiality there. And of course, it improves access to justice and is also being used for not only for domestic disputes, but also international disputes. Now, a lot has been said about the benefits. To have a proper conversation on the future of mediation, is also important to also highlight some of the challenges that are bound where ODR is concerned. Top on the list is what I would like to call the desensitization. Now we are having this training. Some people have their videos switched off. I don't know whether they're actually listening to me or not. So now when it comes to disputes, some parties can decide to have their videos switched off. So, and as much as we mediators may tell them to have it switched on, if they tell you they're having bandwidth problem, there's really so much you can do. And from experience, once there's a psychology to actually seeing parties where disputes are involved, but when there is that loss of face-to-face, you know, there's no human interaction. It doesn't make disputes resolution go on that seamlessly. So of course, like I explained earlier on, parties can actually exit an online meeting faster than they can actually exit a face-to-face meeting. So those are some of the challenges. And there is also a higher chance of misbehavior online as opposed to when parties see. That is why, like I alluded earlier on, there's a mindset to mediation. There is a psychology to mediation. And as much as we may try to say that that there are security, that the security features online, but once in a while you might actually have privacy breach risk, which rarely happens compared to face-to-face mediation. Now, like I stated earlier on, while still looking at some of the downsides of ODR, it's also very important to also highlight some of the key issues and challenges in mediation, top of which is awareness. Now, awareness to the effect that this is 2023, and it starts to state that we're still having conversations on the misconceived notion of the non-bindingness of mediation, where some people still believe that mediation is not binding. And one thing I always ask when conversations like this come up is that the end product of a successful mediation is the terms of settlement. A term of settlement is a contract. Is a contract not binding? And of course, because people don't like change, most times they have this fixed way of having disputes resolved. It's either litigation or no way at all. And they sometimes forget that when it comes to resolving disputes using litigation, it's almost linear. And depending on your country or the jurisdiction you come from, I will use Nigeria as a case in point. You have the magistrate court, you have the high court. If the cases are not resolved at the high court, you move over to the court of appeal. If it's not resolved at the court of appeal, you move over to the Supreme Court. Can you see the gradual progression? But when it comes to ADR, it's like this. You can choose to go through negotiation, you can choose to go through mediation, you can choose to go through arbitration. So a lot of people are still resistant to change. And it's also a bit sad that some lawyers, not all lawyers, are also not in alignment with mediation. And where I come from, some mischief makers like to call ADR as an alarming drop in revenue. They have not been able to see the value chain in mediation. They've not been able to see the benefits of mediation. And let's also remember that most times when issues abound, the first port of call really are the lawyers. So most times when the clients speak to their lawyers and the lawyers tell them, oh, let's not go through mediation and all of that, sometimes some of them actually listen to it. But it's actually changing now. The clients, the customers, they are now beginning to ask the right questions. And what are the right questions? The right questions are this. Number one, can you guarantee that I can have this dispute resolved within a particular period of time? That's number one. Number two is that, can you also assure me that if this dispute is resolved, there is can there be a restoration of relationship? So these are the questions that is being asked. And one thing I tell people as far as the business and practice of mediation is concerned is that I have a dream, and the dream is in the not too distant future, people should see dispute as not a bad thing. Dispute is not a virus. It's part of life. There should not be dispute should not be seen as as a winner takes all. There should actually be a process towards having dispute resolved. The end users, the clients, the parties should be able to exercise the option where dispute is concerned. And one thing ADR is doing is that ADR is actually bringing the worlds together to the effect that I can practice mediation here like I'm doing here in Nigeria. I can practice mediation in the US. I can practice mediation practically anywhere around the world because the cardinal principles of mediation are the same. So that is the ultimate dream at the end of the day. Now, ladies and gentlemen, a lot has been said. I'm sure somewhere along the line, some people are beginning to consider mediation. But at the end of the day, a lot of times this might be an idea. So the question I'm going to ask is that within the broad framework of it being an idea, what steps are you going to take to try to implement some of this? And even in trying to implement them, how consistent will you be in trying to see to it that they all come into realization? So that's where I'm going to stop my slide for today. And there is a reason why I decided to run through all of this. Because one thing I try to say is that engagement is the strength of clarity. So I'm hoping that there will be questions that will be asked for me to be able to shed light on more of these things. And thank you all for your time.
Are you ready to become the change you want to see in your community or in your workplace? If so, check out our tailored workshops and mediation skills, training and certifications designed to equip you with the practical skills to become an effective conflict resolver and a certified mediation practitioner. Now, let's get back to the show. Thank you so very much for that insightful presentation. At this point, we are going to open the floor for members in the attendance. If you have any question, you can unmute yourself and you ask your questions. While we wait on members to ask their questions, I have one. question that I would love to ask. What is your take in the notion that ODR and artificial intelligence takes away the satisfaction which is obtained from the process itself?
Thank you so much, Francis. Let's look at what, of course, we know what technology is, but let's look at what artificial intelligence really is all about. Artificial intelligence works with data. So that means that if data on something is non-existent, then what is the computer or technology going to rely on? That's number one. Number two is this. Let's also look at the framework of mediation. Now, mediation is not cast in legalese. You know, you don't have us banding legal words and all that. A lot of times, it's essentially premised on facts. And one thing about mediation that and there's also a level of empathy involved. So, and now, as much as you have cardinal principles of mediation and what it is you have to follow, a computer does not have an intuition, you know. So if at the end of the day, someone is seated and is displaying a level of emotion, how can artificial intelligence sort that out? So now, but you see, we need to also understand that AI is a tool, just like technology, and a tool is supposed to make something better. Now, it's not as if, okay, fine, you go in there, it's asking for there are automated steps that need to be followed. Where mediation is concerned, sometimes if especially for those who practice mediation, you know what we call caucusing. Caucusing is especially when you have private conversations with parties. And you see, caucusing is a lot like opening a safe. You know, you have to be careful when you call into caucusing. If it is too early, it might be premature. If it is too late, it is a problem. So you see, so these are things that have intuitions involved. So how can AI leverage on that? So most times when conversations come up about AI taking over mediation, technology taking over mediation, I say, no, it is a tool. It is a tool. It's just like it can be likened to you saying now that, oh, because now we have cars that don't need drivers, that they essentially take over cars that have drivers. You know, it doesn't work like that. So once you see these things as a tool that can accentuate, that can make things faster for you, you know, the conversation is entirely different. So that's my response to it.
Thank you so very much for that insightful response. There is a question from Carol in the chat, and I would love to bring your attention to that.
Okay. What is the impact of ODR, cyber regulations, and sharing participant information privacy? Now, so you see, as far as mediation is concerned, as far as mediation is subsumed under ODR, it's actually evolving. And I dare say, as I speak right now, I don't have an informed response to the synergy of ODR and cyber regulations right now. So I don't think, as we speak right now, I know of this. But in terms of the impact of ODR into cyber regulations and sharing participant information, I dare say that is the general law that still applies. So I'm careful not to give a response to this because I don't think I know the answer. The second one is, will we see a cost in training for mediation using ODR? So I think it's actually important to put the concept of ODR in perspective, Carol. ADR is an umbrella form of having disputes resolved outside of the courtroom. So ODR, I dare say, is almost like a tool, like what we're doing right now, you know. So when you make use of technology, when you make use of ODR platforms, when you make use of emails and whatnot, that essentially is what ODR is all about. Now, if this were to be a class on ODR, we're going to also look at types of communications under ODR. We have the synchronous, we have the asynchronous. For the synchronous, I think that one has to do with where you get an instantaneous response. I think I always keep mixing the synchronous and asynchronous, but I know for one type of communication, one has to do with an instantaneous response. For emails and whatnot, you don't exactly have an instantaneous response. So let's not get it all mixed up. as far as ADR, ODR is, So once you make use of technology in having disputes resolved, once you have to stay in the comfort of your homes or your office to use technology in having disputes resolved, that is ODR. So yes, and to your question on whether there will be trainings regarding some of this, it basically it depends on the platform you want to use. Now, for some countries that mediation is just evolving, most of the time they prefer to use Zoom because, like I explained earlier on, Zoom is global, Zoom is easier to use. In some advanced countries, we have some of them using Modron, we have some of them using Crack. We have bespoke ODR platforms. Now, for those type of platforms, yes, there may be a need to have a training on the use of those platforms, not only for the mediators, but also for the parties involved. But generally speaking, most times people just tend to use online platforms like this. Yes, thank you.
Are you ready to become the change you want to see in your community or in your workplace? If so, check out our tailored workshops and mediation skills, training, and certification designed to equip you with the practical skills to become an effective conflict resolver and a certified mediation practitioner. Now, let's get back to the show.
We have a question in the LinkedIn Live. Adeola asks, she says, thank you so much for the presentation. As a mediator, how do we enforce terms of settlement?
Okay, now, the enforcement of terms of settlement, I'm going to use Nigeria as a case in point. Now, let's first of all understand that the terms of settlement is a contract. Now, and a contract is binding. Now, here in Nigeria, there are two ways of going about it. Now, if the case is if it's court referred, and essentially what court referred means is that maybe the action was filed in court, and either the parties or the judge has requested for the party to move to mediation. Once there is a terms of settlement duly executed by both parties, now the terms of settlement will be taken back to court, and it will be enforced as a consent judgment between both parties. Now, once it has been enforced, so it evolves from being a contract into a judgment. And whichever way and manner a judgment will be enforced would also be the same way the terms of settlement will be enforced in the event of a breach. However, if it's a private mediation wherein parties have elected to have their matters settled without having to go to court. Now, the terms of settlement is also a two-way thing. You can actually take that terms of settlement back to court. This is where it gets a bit technical for the non-lawyers. It can be attached as an exhibit and filed through originating summons. That is one method. The second method is that, depending on your jurisdiction, especially here in Nigeria, what we do is that there is an ADR judge, and the ADR judge can actually adopt the terms of settlement to be a consent judgment between both parties. But like I stated earlier on, some of this concept they are Jew-specific, but this is how it operates here in Nigeria. But I would respectfully crave your indulgence if you are outside Nigeria to also just try and find out how terms are enforced. But in pretty much some of the jurisdictions I know, they pretty much follow this and this step that I mentioned.
Thank you so much, Mr. Alade, for your response. And I'm just gonna add something very small, which is in agreement with what you have stated, that when it comes to enforcement, it varies depending on your jurisdiction. For me, what I tell people or what I tell mediators is that reaching agreement is one thing, but is that the most important thing you want to do as a mediator? In my opinion, no. The most important thing is, number one, clarity. And then from that clarity becomes an agreement. Because if you have that clarity and you are able to lead parties to reach, a clear and a wise agreement, it becomes easy to enforce it. Aside from, enforcement from the notion of court ordering party to follow through on that agreement. If you reach an agreement, parties are even more willing to enforce those agreements on their own. And as a mediator, you can, ensure that when parties are in the mediation room with you, you do all that you can do so that whatever comes out of that mediation can live beyond the mediation room itself.
Yeah, very well said, Frank. And this is also where the competence of a mediator comes into place. And one thing I always tell people is that, you see, once a mediator does his job the way he should do a job, the issue of an enforcement should not actually come into place, if you ask me. Because when we're talking about enforcing something, there's a presumption that there's a breach somewhere. So that breach is what we're trying to look at to enforce. So most times, the capacity, the professional expertise of a mediator really comes into question for you to ensure that you make sure your mediation is properly handled, so that the issue of enforcement and whatnot may not also come into place. Thank you.
I was just wondering about, just to fill you in, you probably already know, I wouldn't surprise you do, but yesterday in London we had the decision in Churchill and Mother Tidville handed down, which is saying that we can now order, finally catching up with Nigeria, we can actually direct people. The courts can direct people to mediate. 20 years this has taken us to get around here. You guys are well ahead. And we have a new abbreviation. It's not ADR. It's now non-court-based dispute resolution, NCBDR. I've been practicing that all day for this webinar. NCBDR.
That's a mouthful, Tony. NCBDR. That's going to take a lot of getting used to, So the question I'm going to ask you, as far as that is concerned, is that are parties going to be forced to settle, or will parties just be forced to attend the mediation session? Because I struggle with how this comes into place, especially where the voluntariness of parties are concerned.
Yeah. So my understanding, and it's a very narrow decision, but there are some issues we've yet to work out, is that they're going to be directed to engage in a process. It could be ad hoc negotiation, it could be an internal complaints process, or it could even be mediation. They're required to engage. And I think that probably just means turn up. But they're not required to settle, because that would block the Article 6 human rights point, European human rights point. You're familiar with that?
Yeah. Thank you so much, Tony. Okay, yeah, I think I saw a question from Siddharth. He says that ADR with personal touch factors plays an important role. When does ODR comes into place post-COVID? Is it reliable for the primary meetings? So like I stated earlier on, Siddharth, you see, ODR really is a tool, and it's a tool of convenience. So I really don't want us to overthink ODR or overthink ODR. The essence of ODR, really, if you ask me, is a tool to make ADR faster and better. So it all depends on whichever way and manner you want to do it. Like I mediate at the Court of Appeal, and we have more or less a cocktail of ADR and ODR. Sometimes we start off with parties meeting physically, then sometimes, depending on convenience, we can decide to have the future sessions virtually. So it's really a case of a mix and match. So if you feel that you want ODR or ADR to be the primary meeting, you can always do that. So it all depends on what you find most convenient and comfortable for you.
There's a question. Christina?
Hello. Greetings from Canada, everyone. It's not so much of a question. It's more like a comment to say that I'm happy to be here to share and to listen and to learn from each other, because the culture can make mediation and ADR so much different. Because one thing may apply to Nigeria, it might not apply to Canada. It is same and it is different, if you understand what I'm saying. But what I'm saying is good to connect as mediators or conflict resolution professionals. It's good to connect to share so we can have panel discussions, wherever, whatever platform, to share and to learn more about each other, culture, the sameness and the differences as well. I'm really from Jamaica, but I reside in Canada. Thank you for inviting me. I'm happy to be here. Have a great one. Thank you.
Yeah, thanks so much, Christina. And I like the fact that Christina has actually brought in culture into play. And you see, you cannot extricate culture from mediation. Now, for some of for those of us from Nigeria, Nigeria is very big on respect, So now, like Tony is my friend right now, so I can be on a first name basis with Tony. So if this were to be a standard mediation session, I probably may not be able to call Tony Tony. I would have to probably call Tony a Mr. Tony, call Tony an Uncle Tony, and all of that. And you see, because of the dynamics of mediation, you're careful not to want to assume that a party wants to be on a first name basis with you. So that's why even in mediation sessions outside of Nigeria, I always ask parties, how do you want to be addressed? So you see, so you cannot extricate culture from the scheme of things. And even right now, in the present day world we are in right now, pronouns are very important. You can't assume somebody wants to be addressed as a he. Someone might want to be addressed as a he, she. Someone wants to be addressed as a they, them. So these are conversations that we really should start having where mediation is concerned. So you cannot extricate culture from the scheme of things. And because of the universality of mediation, as far as it's concerned, to the effect that you can actually practice mediation practically everywhere. One thing that comes into play, one, is the fact that as mediators, we must be culturally sensitive. That's very important. Apart from even the issue of cultural sensitivity, emotional intelligence too is also very important. So it's one thing to be a good mediator, but there are also ancillary soft skills that you can have that can actually accentuate your practice as a mediator.
Thank you, Fowler. I just want to expound on what you're saying. You're right. Because my background from Jamaica as a teacher, we refer to each other by last name with Mr., Mrs., or whatever you want to add to your name. Like back home would be Mrs. Godden. Here in Canada, we are familiar with each other first name. If you're a lawyer, it's Tony. I'm using Tony as an example now. If you're in Jamaica, it would be Mr. Guys. You understand? So you touch a very critical point there. Another thing you spoke about, in Canada, you can't just go about to say, if I look on you, follow, and say, he said, or him this, or him that. You can't do that. You understand? Because a person might not want to be referred to as him or her. You have to know how. And the important thing is that you had mentioned that as well. Ask the person, or would you like to be addressed? Mediation, whatever the culture, wherever you are, it is important. Ask, or would you like to be addressed? Very important.
Yeah, thank you so much, Christina. And another point to also mention again, added to what Christina has stated, is dynamism in mediation. Mediation is evolving and it's coming up so fast that you can't just assume that the knowledge you have of mediation a year ago is still valid. You just find out that, oh, I had this knowledge about mediation. Something else has come into play. That is why I always encourage conversations like this on mediation. And if you look at it, the cardinal principles are the same. It's just the applications that sometimes differ. So when we stay here and we have conversations on it, look at Tony talking about the enabling law as far as mediation is concerned, as far as it being quote and unquote mandatory. Now that is another conversation for another. It's a symposium conversation, because some schools of thought will tell you that the fact that people are even being forced, quote and unquote, whether they should settle or not, invalidates the principle of voluntariness. Because even the concept of voluntariness in mediation is a two-edged sword. We have some people that can't practice mediation because they don't understand. They feel human beings will abuse the concept of free will. And some seasoned mediators will tell you that mediation is more difficult than arbitration. Mediation is more difficult than litigation, because when it comes to arbitration and litigation, there are set rules. There are set rules that must be followed. In mediation, is not like that. So it now begs the question that, okay, fine, human beings are born to be free. So are we mismanaging free will where mediation is concerned? So you see, it's a conversation that once we start off, it starts taking up. Look at how Christina mentioned, look at where I'm coming in from, somebody also coming from this dynamic and all of that and everything. So it's actually very, 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 very interesting. But one thing you can't take away from mediation, and I always make people understand, is that, you see, it's tied to the very fabric of human existence. And once you have an understanding of conflict, and you start seeing conflict in its proper form, to the effect that it is not only innate, but it's as old as mankind, you know that conflict is not going anywhere anytime soon. If conflict could be extinguished, I think it would have been extinguished a long time ago.
I'll chip in a perspective, if I may, from England and Wales. And it's like ADR is washing over us now. We are embracing, encouraged by our Master of the Rolls, head of the Civil Division of the Court of Appeal. He is leading the way. He is our Constantine. He is our Constantine. And now I think the lawyers who for years have feared a dramatic, an accelerated depreciation of revenue, they now see ADR as a fee base, and not immediately, but I think over the next 2 years we're going to move to a very fulsome embrace of ADR in England and Wales, and ultimately that is going to be managed by platforms, online dispute management platforms, where everything is uploaded, downloaded with bespoke, as you were mentioning, Fola, in your talk, bespoke functionality for mediations, so you can keep confidential messages to the mediator, as you know you have to, as we all know here. So it's a very informed audience that TC Mediation have drawn together, and that will speed up the whole process. But it also requires a new mindset. So instead of having maybe 4 or 5 mediations a week in England and Wales, I know in Lagos you have a lot more, but instead of 4 or 5 mediations per mediator a week, you're going to have 400 or 500 a day, and so that's going to require the AI that you rightly drew attention to enable that to speed up. And we're looking at that and trying to find use cases not to replace the mediator, as people often fear, but to support the mediator, to appoint the mediator, to draw the parties together, and maybe one day to suggest possible settlement outcomes. But that's in the future.
Thank you for listening. We hope you enjoyed today's episode. You can support us by leaving a 5-star review. And if you haven't already, please subscribe to this podcast to stay informed whenever we upload a new episode. See you in the next episode.